Ron, where are you? Where is Ron right now? You done messed up, Ron!
Ron is right here with Zac Morgan. How's it going?
I'm good, Aaron, and happy long weekend to your visitors. Monday is a federal holiday. Some may have to work, some may have the luxury of staying home. So happy weekend, everybody.
I totally forgot about that. Yes, the kids have a 3-day weekend from school. They're loving it. Okay, so let's get right into it. Let's start this out assuming that someone's watching us right now and they don't know about the video yesterday regarding the Danny Masterson jury foreman scandal. In a nutshell, the 30-second version here is that the foreman of the jury foreman of the Danny Masterson criminal trial, it was found out yesterday, I revealed on this channel yesterday, that he himself has a son who was convicted of crimes not very dissimilar to the crimes Danny Masterson was on trial for. And not only was he convicted, but he was prosecuted and convicted by the exact same office that was prosecuting Danny Masterson. That, in my lowly opinion, as someone who just grew up in a cult and doesn't know anything else, seems like a massive conflict that would most likely preclude someone from being selected for a jury. And without rehashing the entire 30-minute video that I did yesterday, that was the crux of it. Now, before I ask for your comments on the substance of the matter, I did receive a privacy complaint on that video. Somebody submitted a privacy complaint to YouTube. It doesn't mean it was Earl Batiste himself who submitted that complaint. I know from experience that you can submit such complaints on behalf of anybody. It doesn't mean it was him. But it was a 30-minute video, and the complaint said privacy was violated between minute 2 and minute 23. Okay, so let me just ask you, I want to start this video on that topic, okay? In your opinion as an attorney, does Earl Batiste's position as a jury foreman, this will be a multi-part question.
Sure.
Does his position as a foreman make him in any way a public figure? The second point would be, does the fact that he submitted a legal affidavit for the defense attorneys make him a public figure? Or does the fact that he did an interview with a journalist identifying himself as the Masterson jury foreman elevate his status as a public figure? What say you?
So in order, it would be no, yes, and we'll explain those. All right. So the fact that you serve on a jury doesn't make you any more of a public figure than a person who goes about their daily life. Essentially, that becomes your occupation for the period of time of the jury trial. It doesn't make you any more or less of a public person than you were before. So, for example, if Tom Hanks, right, the actor who I think wants to play every living person before he dies, if Tom Hanks is called to serve on a jury, then he is just as famous before and just as famous after. His status as a public or private figure doesn't change because he was on a jury or a foreman of a jury. President Obama, after he left the White House, was at his residence is in Illinois. He was called to serve on a jury on jury duty in Chicago. So he showed up and he was still with his Secret Service detail. He did all the things he was supposed to do. He was just as famous before and after. He was famous before, so he's famous after. The fact that a person fills out an affidavit as a witness in a case, as the foreman did for Masterson's motion to dismiss, doesn't make you any more of a public person than it did before. Just as being called to testify at a courtroom that is a public hearing, a public trial, but which nobody otherwise cares because it's not a famous person, nothing would change. Where a person's status as a private person changes to a public person is when you start giving interviews on the record and choose to be identified to journalists.
So somebody would argue he chose not to use his last name. He only called himself Earl.
That's true. But he also did it podcast format where his voice was made available. So even though I don't know this individual, if I was his neighbor or I went to church with this man or I worked with this man, I would recognize his voice and go, oh, that's Earl from work. That's Earl from church. That's Earl, my neighbor. I now know who that person is. Mm-hmm. Right. It was different. And I know this predates both of us, but if you go back to the Watergate scandal, with the Washington Post, one of their sources was called Deep Throat. One of their sources, it was confirming information, was giving information on the record, but said, do not identify me. We now know that person was the second highest ranking person in the FBI, a guy named Mark Felt. He did not want to become a public person, even though he was talking to journalists. So he structured his relationship with them in a way such that his identity would not be disclosed.
And was his voice not identifiable in the recordings?
Well, it was never recorded because it was written in the Washington Post published it in a series of news articles. So they would take notes, but there was never any recordings of the discussions between the reporting staff and the source.
I got it. Now, also, you know, in the interview, there was reference made to the fact that it was Earl's daughter who made the introduction between Earl and Chris Shelton. And yet Earl's daughter on Facebook is friends with some former Scientologists, and Earl's daughter comments on Earl's Facebook page and his son's Facebook page and his grandson's Facebook page. So anyone with access to the internet could connect dots. Nothing proprietary was revealed,
No,
to the best of my knowledge.
Yeah, all the information that you gave comes from public sources, right? The fact that the foreman's son, I believe it's his son, who is a convict in his own right and on a registry, and that I believe his grandson is an actor. If that grandson has any acting credits, those acting credits are public. The son that is on the registry, that registry is public.
Right.
I mean, that information is publicly available, so there's nothing proprietary about it. And every person has a right to privacy. Even public people have rights to privacy. But what constitutes the reasonable right to privacy varies based on whether the person is a public person, a limited public person, or a private person. And there's a couple of famous court cases that set that out. The first one, and I think they're fascinating court. The first one is Jerry Falwell versus Hustler magazine. And some of your viewers may have heard of that. Jerry Falwell, of course, the evangelical preacher from the East Coast, founded Liberty University. Back several years ago, I think it's in the 80s, Hustler magazine ran a parody ad on the back cover that talked about a specific encounter, which would have been the first encounter of that type that Jerry Falwell had, and happened to be while intoxicated with his mother in an outhouse.
So wait, this was what the movie The People versus Larry Flint was about, right?
Yeah.
Yeah.
Well,
okay.
in part, but yeah.
Yeah. And so what was the issue? What was that issue in the lawsuit? Whether he was a public figure or whether that was in fact slander or libel?
Yeah. So he sued. So ultimately it became both, but he sued Larry Flint and Hustler magazine because it is an untrue statement, right? And defamation, slander, and libel, the defamatory torts, are based on false statements. But the difference is Hustler magazine, in about 4 different ways, said this is a parody. When you looked at the table of contents in the front, it was like back cover parody, page 26. And then when you turn to it in fine print at the bottom, this is a comedic sketch. This is not true. Like, they made it very clear. This is not serious. We're poking fun of famous people.
Right. Well, I remember the famous line.
He lost the lawsuit.
I remember the famous defense, which was, now, isn't it possible that he really did do this with his mother? And they were like, no. Well, couldn't a reasonable person believe that this was possible? No. Well, then it's not slander.
Yeah. That's one of the rules of defamatory torts, is that the statement must be a fact. It must be made to a person it must be made to a third party. So in this case, a statement made to somebody other than Jerry Falwell, and that it has to be reasonably believable by the person, and that's not even close.
Right. And thankfully, that's not what we're talking about here, because there's nothing I said that was satire or anything. It was all completely documented. And I was very clear in my video about what I was stating that was factual. And even then, I soft pedaled that a little bit, because any of it could be proven false. I was very clear on what I was claiming and what I was speculating about. So let's get into that.
Sure.
I am, for the purposes of this video, I'm going to stipulate that. Do you like I'm using big words? You like that?
I do. First off, before you go there, Terry, I saw that super chat. I appreciate those kind words. Thank you very much.
I'm going to stipulate that Earl does in fact have a son approximately my age who is in fact convicted of crimes against children and for the rest of his life has to be on a certain registry, and that he does have a grandson who's either an actor or a working actor, and that having someone on the jury with that baggage, if he did not disclose that this would in fact, well, let me frame it as an actual question for you.
Sure.
If he did not disclose that, what are we talking about here?
So there's a lot of variables. So one, I don't know, different courts do it different ways. Some places send out jury questionnaires. Some places allow the attorneys to question jurors directly. Some it's all done by the judge. But in any event, the jurors are subject to voir dire. Some places call it voir dire. In the South, we call it voir dire.
Voir dire.
Yeah, different places call it different things. But essentially, it's the jury's, the individual prospective jurors at that point. They're being evaluated by the attorneys for their fitness to serve. And I don't know what questions were asked, but if a question of, do you have any connection to Scientology? Does anybody in your family, to your knowledge, have a connection? Do you know of anybody who has ever been convicted of a crime of this nature of which Danny Masterson is charged? Are you familiar with the registry with that people have to be on after they're convicted of certain crimes? If those questions were asked and the foreman's answer was no, that's an untrue statement. And as you start on a jury, so you know this, you have to raise your right hand when you start to answer those questions that are presented to you by the attorneys. I don't know if any of those questions were asked. If none of those questions were asked, then theoretically he told the truth. And I have no knowledge as to what the questions were asked, so I'm certainly not making an implication whether he was or was not truthful.
So yeah, that's actually what I wanted to ask you, is there any are these questionnaires to a certain extent standardized? Is there any chance that a question such as, do you have a family member, a close relative with a felony conviction, is there any chance that question would not be on the questionnaire?
So there's probably some boilerplate questions that are available, but questionnaires, if they're requested by the attorneys and granted, the attorneys get to create their own questionnaire, and then the judge says, yeah, you don't get to ask that, but you do get to ask this, you do get to ask that, whatever.
Right.
And so I've done both. In Oklahoma, it sort of varies even judge by judge. I've had some judges give questionnaires. Some judges say, ask him when you get here. It all sort of depends. The other thing is the judge will actually interview the jury first, the jurors individually. Is there anybody here who for any reason feels like they can't serve on this jury and cannot be impartial? That's a catch-all question. Like I've had some where I had a woman who said English was her second language. And although she understood the jury examination process, she was worried that when we called expert witnesses, she wouldn't understand some of the bigger words the doctors used. And she asked to be excused. We didn't have a problem with that. I want my jurors to understand every question that's asked and every answer that's given. It's important to me. I had no problem with that. Another individual said that he felt like he was unable to serve because he had an adverse, his family had an adverse situation in which a family member of his was involved in a car accident and had an unfavorable verdict entered against them. So we examined him. So the judge examined him on it specifically. And the guy said, well, I feel like I can be impartial. I tend to not like cases like this, but that doesn't mean I'm not willing to listen to the evidence. And the judge says, that's good enough. You get to stay and try this case. Ultimately, he was on the jury and I ended up with a favorable verdict.
Right. And, to the best of my understanding, it's not that these things that I revealed are immediately and automatically disqualifying. It's very possible. Let's just say that we live in a version of reality where all of the appropriate questions were asked and Earl did actually fully and truthfully answer those questions. It's not like that's an immediate disqualification. How would the attorneys have handled it if he did disclose the things that we're talking about?
Well, so ultimately, it would come down to lawyers and parties have the right to kick people off the jury for any reason whatsoever. We call that peremptory challenge. So let's say they're seating 12, they bring 18 into the courtroom, and each side gets to kick off 3 people. That's 6. 18 minus 6 is 12. I didn't grow up in a cult, but I don't do math so hot, but even I can manage that. So that's how we get to the math, right? But if I see somebody, for example, I had a case in which one of the witnesses or one of the prospective jurors worked with the husband of one of the attorneys. So we challenged that person for cause. Judge, we think this is a fine individual, and on any other case they would be qualified to serve, except they work with the husband of the other attorney. So we challenged them for cause. Another person, said that they were biased against defendants or biased against plaintiffs, or felt like the court system was rigged against, whatever. We challenged that person and said that they were unfit to serve, not on all juries, but on this jury. Then at the end, there's 18 left over, and then we can kick anybody for any reason. So I pick my top 3. Here's the 3 I want gone. And then let's say I get lucky and the defense kicks one of mine also. We both had the same person. Now I need a backup person, right? I need my
Right.
4th, theoretically. So if, assuming Earl answers all the questions correctly, I have no reason to believe that he withheld any information. It's then incumbent upon the attorneys, specifically the prosecutors, to determine, can this person serve? Right. And when you're asking jurors questions, you can ask them very specific questions. Earl, I've got a question for you. I know that you indicated earlier that you have a son who's a convicted felon. Do you believe that he was treated fairly by the justice system? Do you believe that, right? So you can inquire specifically as to that juror and say, hey, he may say, hey, my son has made some terrible choices. I love my son, but he made bad choices. I feel like justice was served, or he may have a bias against it, but it's incumbent upon the attorneys to inquire as to that.
The fact that Earl was asked some questions in a voir dire and it had nothing to do with any of this is what makes me go, even without having seen the questionnaires, either the precise question wasn't asked or Earl didn't disclose, because all he was pressed on was, Earl, I see you work for the TSA, which, by the way, makes me go, that's not true. He might have used to work for the TSA, but he didn't when the trial was going on. To the best of my knowledge, I could be wrong, but I go, whoa, that's another piece of information that doesn't jive. They're like, you work for the government, you work for the TSA. Do you think prosecutors are inherently more believable than defense attorneys? And I'm like, that's what you're asking him about when he's got this other giant elephant sitting there that seems to have bearing on this case? That's what makes me go, something's going to come out here. Once someone I know is looking into these questionnaires, someone's going to write something about these questionnaires. We're going to see. Let me turn this into an actual question for you. If you were a prosecutor on this case and you saw that a juror had in his past or in his family what we're talking about here, would you definitely ask about it? Would it like it? Would you 100% feel that that was something germane to this case?
Oh, absolutely. I'm now, if I'm on a time limited voir dire, I have to sort of pick my battle. How much time do I want to invest in? Do I want to spend investigating this versus investigating the rest of these jurors? When I say investigating, examining, and trying to feel it out, but probably not the right time to use feel it out, but you get the idea. So if I'm a prosecutor, I'm definitely going to work that juror a little bit. I'm going to get as much information as I can. Do you believe the justice system was fair? Do you believe that your family member was wrongfully convicted, or do you believe he did what he did? What do you believe should happen to people who are convicted of crimes like this if the evidence is there? Do you believe that there is enough sufficient evidence to convict somebody of this crime, or are you of the position that there's never enough evidence? I need to know that. And so I would definitely allocate time and resources to examining this juror more specifically.
Right. Because would it be accurate to say that the entire voir dire process is essentially trying to ferret out biases and conflicts? I mean, that's pretty much what you're looking for, right? Biases or conflicts.
Exactly. And sometimes biases and biases are to my benefit. And if I feel like somebody is biased in my favor, it's not my job to flesh it out. In fact, I want to move on to a different line of questioning rapidly and hope that I distract somebody else along the way. But the other attorney needs to be going, hey, I think I detect a defense friendly or a plaintiff friendly bias here. If I'm the other attorney, I want to go and explore that bias. And so we're given attorneys are given a big spreadsheet where we get to write in information about these various jurors. So I'm filling that information in, and I've also got a notebook of questions I'm coming up with. I have a set of stock questions, but then as I hear a question asked, I may say, hey, I want to follow up with him when it's my turn. right? So there's different ways to do it, but it's actually a really difficult process because I'm trying to keep track of where I am on time, where I am in relation to these 18 people in front of me, what information have I heard that's helpful, and trying to remember which one's the plumber, which one's the school teacher, which one's the doctor, and which one is the scientist. Right? I'm trying to keep all of that straight in my head. At the same time, but I'm also trying to listen to everything the person says. I'm reading their body language. I'm trying to read their expression. Are they closed off to the process? Are they leaning forward? Are they otherwise sort of disinterested? Are they listening to other people as that examination is happening? All of those things are important to me, and it's a lot to process.
Right. So if you're in the prosecutor's position there and you're trying to get a read on whether this juror is biased in favor of prosecutors or defendants, it seems like if you knew that this guy had a son who'd been prosecuted for a similar crime by the same office, that would be more important than whether the guy worked for the TSA as far as determining biases. This is why I'm like, there's no way Earl disclosed this. And I know I'm speculating and I know I'm repeating myself, but I hope I'm making a good argument for why that speculation exists. Because
Yeah,
it's not just Deputy DA Mueller personally and single-handedly going over these questionnaires. Isn't there not a team of people going over these questionnaires?
probably. And I can't even conclusively say that there were questionnaires issued.
There were the judge.
Okay, there were. I did see a super chat earlier that one of your viewers was asking, yeah, Tawny, is the juror questionnaire not part of the public record? No, it's not. Because that juror questionnaire often says things, what is your date of birth? What is your physical address? Where do you live? Where do you work? What are your children's names? That starts to get into privacy issues.
Right.
The fact that Aaron has children and he tells us about it, that's Aaron's right. If I have a child, neither my child's name nor image has ever been published on the internet ever. I keep very strict control over that because for a variety of reasons, not the least of which, as an attorney, when I was practicing some criminal defense law, sometimes you represent people that you don't always want knowing a lot about you or your family.
Right. So those records aren't public. They're not even public after the case ends, but the DA's office can go back and review them, right? Because they're there. I mean, they're part of the record, right?
Yeah, they are part of the record, but they would be sealed. In fact, the names of the jurors who are selected is part of the court file, but it will never be made public. Jurors only become public when they choose to become public. The fact that they served on the O.J. Simpson case or the Danny Masterson case or the Johnny Depp case, the only way we ever know who they are is because they choose to be identified. That information, while part of the court record, is never available to the public.
Wow. Very interesting. Okay, you can check your email, Zach, for an email from Marjan.
I will do that.
Okay, so where else do I want to go with this? So look, the case is that trial is already over. It's done, dead and buried. It's going to be retried. Oh yeah, this is what I wanted to ask you about this. How unusual or strange is it to see the foreman actually fill out an affidavit in an effort to help the defense get the charges thrown away? And what would you infer from that?
I've never known it to be done. Ever. I've never known it to be done. Obviously, he was. It sounds like he was in the camp that voted to acquit on all three charges. Right? We know that there were three different votes, three different divisions. I think the closest they got was 7 not guilty, 5 guilty. I think was the heaviest guilty count. Clearly, or I shouldn't say clearly, it certainly appears to me if he is signing an affidavit that says no reasonable jury could ever convict this individual, the judge or the court should dismiss these charges. That appears to me to be pretty cut and dry that he was in favor of the acquittal camp. I've never known of a juror to ever fill out an affidavit on a mistrial about the future of a case. I have seen where jurors have filled out affidavits that say, I was bullied, or somebody in the jury room brought into deliberations things that we were not allowed to.
Right.
Well, witness X said so and so, but I looked on Google and found this and that. No, you can't do that. You can't go outside the information submitted at trial, the evidence and the testimony at trial. So I have seen that from time to time. But I've never seen where a juror has said, "Hey, we're going to do this. This case should never be retried. No reasonable jury should ever get there." And the judge did exactly what the judge should have done. Said, "This is absolute nonsense. I'm going to throw this away. This has no legal effect, no legal bearing. It's a basically worthless piece of paper that the defense probably paid several $1,000s for." And well, I shouldn't say that. I do, and I have to make this disclaimer. In most jurisdictions, including all the jurisdictions in which I practice and am admitted to practice, witnesses are entitled to be paid for their testimony. Okay. And so unless I'm an expert witness where I'm charging, an hourly rate or something, it's normally a nominal fee. In Oklahoma, I think it's like $29 plus mileage if you live more than 50 miles from the courthouse or something. So I don't know that the foreman was paid, but if he was, it's very likely it was both legal to do so and ethical, because an affidavit is testimony. You're allowed to pay somebody for their testimony.
Sure. The fact that, okay, you mentioned a moment ago that you've seen jurors fill out affidavits like, "I was bullied in the deliberation room," and whatnot. That's kind of where my head starts to go, when I try to consider the possibilities here. Because I go, you were the foreman. You're the only juror who desired, agreed, conducted an interview with a journalist, and you filled out an affidavit for the defense attorney. What are you talking about? I can't imagine a world in which he wasn't back there arguing and, I don't want to say pressuring, because how the hell do I know? I just can't imagine a world where he wasn't in there acting as a meaningful force trying to get people to acquit. I don't see it.
I agree. I don't know that's terribly helpful. Obviously, the judge saw right through it. I think it's a grasp at straws sort of thing. The Danny Masterson's attorneys, they have the right to bill for their time. They have a legal obligation to advocate for their client. And I would argue that they had an obligation to write and file that motion. But if I ask the court for relief, I can't just say no reasonable jury would ever convict this individual. I have to back it up with evidence, and they had to go get the evidence. In this case, the evidence was the testimony of the foreman. Doesn't mean I agree with it. And obviously the judge didn't either. The judge said that there's nothing here, but I would argue that the attorney had an obligation to at least try.
But let me ask you this, Zach. Could they have submitted their motion purely based on the interview Earl did without actually getting him to sign an affidavit?
They could have cited to that interview, certainly. And I'm sure they probably did, but they could have just cited to the interview as well, but it wouldn't have made any additional bearing, really.
Sure. But I'm saying they didn't have to have an affidavit from Earl in order to file that motion to dismiss the charges, right?
Of course not.
That's what I'm saying. Like, and also, I don't know. I know you didn't watch the whole video on the subject last night, but did you see the part where and this is where I got into what some might call rank speculation about, did Cohen know that Earl had this thing in his background, and was he leveraging this knowledge during the trial? And is it possible that Earl was already talking to the defense team before doing the interview with Tony Ortega? I laid out what I thought was a relatively convincing argument, but I'm wondering, did you see that part of the video though?
Yeah, sort of the highlights. It's very possible. We'll never know. What I will say is this: if during the trial, any of the attorneys, the assistant DA, any of the DAs, or any of the defense attorneys knew or came upon knowledge about Earl's family, they had a duty to disclose that. More importantly, if they found that out and realized that some of those facts were different than the answers Earl gave, they also have a duty to report that. So there's a few things bouncing around in there. There's a couple of super chats. Let's grab those. I'm coming up on the end of my allocation, but let's make sure we grab those.
Okay. Will untimely death of Lisa Marie impact the trial? I do not think so. It would have been nice to see Lisa Marie testify in the retrial, but it wasn't a guarantee that she was even going to. So, and really, she was just going to testify that Scientology had tried to get her to help silence one of the defendants. It's not like she was present during the attacks that Danny committed, whereas other witnesses already testified who were present. So, okay, did this juror's information become known because the prosecution found out, or because somebody looked at him because he spoke publicly? It's because somebody looked at him because he spoke publicly. That's the answer to the question. And another one here. Do you think Cohen will try and call this jury foreman as a witness in the new trial?
The answer to that is not only will he not try, he legally cannot. This four-person one, he doesn't know any information. He only knows what he's read. He doesn't have any firsthand experience. He doesn't have any firsthand knowledge. It would all be what he read or what he heard as at the other trial. What happened at the other trial is not admissible.
Right.
Secondly, even if he possessed some sort of information, the witness lists were due months or years ago. Just because I find out something later doesn't mean I get to call that witness. I should have done a better investigation.
Right. Makes sense.
So
okay,
not only can they not only will they not, they can't. So that's the answer.
There you go. Okay, last thing here. In Cohen's closing arguments, he made a statement that people have contacted me since last night and said this statement was completely uncharacteristic. Anyway, remember what Danny Masterson's on trial for. It's horrible attacks against women.
True.
For Cohen to make a closing statement saying it could be my son in that chair. Someone said to me, they go, does your son have a problem with how he treats women? Like, why would you say that? Like, it's not natural to go, my son could be in that position, but knowing that Earl's son not only had been in that position, but was found guilty.
Right. So it's a fine line there, Aaron. That's almost improper argument. One of the things you cannot do when you give closing arguments is you cannot ask the jury to put themselves in the place of either of the parties. And that's as close to doing it as you can. I don't know if there was an objection. I don't know if that statement caught an objection. I would not have been surprised if it did. There's a sort of a gentleman or a gentle lady's understanding between attorneys that we don't object during closing argument unless you're super, super egregious. That's bordering super, super egregious. If it didn't catch an objection, I'm surprised that it didn't. I don't know that it rises to the level of improper argument, but it's awfully deadgum close.
Right. And it just seems like because that is very close to making a major error. True. And you go, and it just so happened to be something that would have really resonated with that. I go, man, it's not evidence. It's not fire, but it's smoke.
It's true. It's absolutely true.
Okay, great. Well, I think we've covered the bases, and I'm sure everyone loves hearing your opinion on this, as do I. So thank you for that. I think we've covered all the super chats, and so we won't linger. Thank you guys for watching and listening. Thanks to everybody who watches until the very end, and I'll talk to you guys soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right